My name is Yury Fedotov, and I am the Executive Director of the United Nations Office on Drugs and Crime. I am pleased to introduce the anti-corruption module of the UN Global Compact and International Bar Association's Lawyers as Leaders project. Current estimates suggest that the global cost of corruption may exceed $1.5 trillion each year. However, the true price of corruption is even more devastating. Corruption undermines democracy, the rule of law, and economic and social development. Every country stands to lose from corruption, but the weakest, perhaps, are more vulnerable. This means that corruption has a disproportionate impact on the world's poorest people. Governments and the international community have been working to curb corruption for decades. The United Nations Convention Against Corruption came into force on the 14th of December 2005 and now has 148 parties. While this demonstrates a strong global commitment to fighting corruption, ongoing efforts are needed to ensure that governments implement the commitments that go along with the ratification of this convention. In addition to helping governments to develop and implement domestic anti-bribery legislation, the United Nations assists states by promoting anti-corruption measures in public and private sectors, including in high-level financial and political circles. Lawyers have a key role to play in tackling corruption. A survey carried out by the International Bar Association in cooperation with the UN Office on Drugs and Crime and the Organization for Economic Cooperation and Development that was released in October 2010 surprised us by revealing that only 36% of lawyers around the world were familiar with the UN Convention Against Corruption. Clearly, for lawyers to become leaders in the fight against corruption, there is a lot of catching up to do. The UN Global Compact is a model partnership between business and international organizations for fostering corporate social responsibility. The level of compliance with the Compact's 10th principle that business should work against corruption in all its forms, including extortion and bribery, will affect the achievement of the Compact's other principles on human rights, labor, and the environment. We must not allow corruption to undermine progress in these and other critical areas, and business can play a key role in preventing this. I thank you for participation.
Hello, my name is John Sherman, and I'm a senior program fellow at the CSRI Institute at the Harvard Kennedy School. And I'll be taking you through this presentation on international and domestic anti-corruption and bribery laws and principles, and the role of business in relation to these laws and the issue of corruption more generally. We'll hear from Huguette Labelle, Chairwoman of Transparency International, which is the leading non-government organization focused on anti-corruption. We'll then hear from Peter Salmson from Legal at Siemens, who will discuss Siemens' experiences dealing with corruption issues and its system of compliance that it's put in place. We'll then hear from Ken Thompson at LexisNexis on their approach to anti-corruption. Huguette Labelle is the chairwoman of Transparency International, which is the leading global civil society organization dedicated to tackling corruption. Huguette Labelle will discuss these international and domestic law frameworks and the role of business in addressing corruption. The 10th principle of the UN Global Compact states, quote, "Businesses should work against corruption in all its forms, including extortion and bribery," end quote. This principle was not part of the original compact, but it was added later in response to the adoption of the UN Convention Against Corruption in 2003 by the UN General Assembly. So how does the international law framework that addresses anti-corruption operate? particularly in relation to companies?
The UN Convention against Corruption is of prime importance to the 10th principle of the UN Global Compact. And this convention has basically four major pillars: prevention, criminalization, asset recovery, and international cooperation. If we look at each one of those, when it comes to prevention, what it does is it requires the state parties to establish institutions, systems in relation to procurement, to administration, public information, which is based on transparency, on competition, as well as being based on ensuring that the information is objective and based on objective criteria. Now, the second one is criminalization, and that one is vital and most important. And what it does, it requires state parties to establish domestic legislation in order to criminalize bribery and corruption. And this really means that it has provisions to ensure that embezzlement, misappropriation, money laundering, either in the private sector or by public official, is really a criminal offense. And it also deals with freezing of assets, it deals with anti-bank secrecy measures, and also some protections for whistleblowers and those that are witnesses in this. So this is a very important aspect of the law, which I think all companies need to look at very carefully. Now, the third major pillar deals with international cooperation. And this is where up to now so much money has left countries around the world to be parked in fiscal havens, in uncooperative banking centers. So what this provision or these provisions do is to ensure that state parties cooperate with each other in providing mutual legal assistance, ensuring that they provide information that they are ready, capable of cooperating with extradition of individuals, the seizing of assets, freezing of assets, and even confiscating of assets. So these are very important in terms of preventing money laundering and ensuring that countries cooperate with each other, that their banking sector will cooperate, so that money that has been taken out of countries by individuals that belong to the people is taken back for the development of the people of those countries. So, international cooperation is very, very important in this regard.
The U.S. Foreign Corrupt Practices Act, commonly referred to as FCPA, is a prime example of domestic anti-bribery law. How does it operate?
Well, the FCPA has been a major milestone in the work against corruption and in bribery outside of one's borders as well as domestically in the United States. And it was basically the FCPA which really was at the origin, up to a point, of the OECD Convention Against Corruption, which was very important in the late and happened in the late 90s. So, and it meant that the members of the OECD, the country members of the OECD, had to give themselves legislation to criminalize activities or bribery by their national companies when this was happening outside of their borders. So this has been a very important piece of legislation, and of course it's still being used in the United States widely by the prosecuting agencies.
In general, how effective has state party compliance with international anti-bribery and corruption obligations been?
Well, you see, right now, we are very early in terms of the UN Convention Against Corruption. So we will all follow this very closely. But in terms of the OECD Convention, there has been quite a range of implementation in countries around the world. Of course, the 30 countries of the OECD have ratified the convention, have given themselves legislation, except the UK, which will hopefully, has now prepared legislation. It's been passed, but not given royal assent. It should be given royal assent in the spring of this coming year. So, you know, we have that. Now, what happens in terms of implementation? We have a small number of countries, US at the top, Germany, Norway, Switzerland, for example, who have a lot of cases in front of the courts and who have prosecuted a number of cases. Then you have another group of companies who have had very few cases and who might be doing a fair amount of investigations, but they didn't seem to have been able to reach the courts. And again, a third group where very little, if any, investigation or prosecution. So there is still a lot of work to do even with the OECD Convention.
Now, given that state parties are not uniformly implementing and enforcing anti-bribery laws, what should business be doing?
I think the private sector has a major role to play here. And I think our advice should be, first of all, ensure that you know what the provisions of these legislations are in your countries. Ensure that you're fully aware of the requirements of the UN Convention Against Corruption as well as the OECD Convention. And then organize yourself to comply voluntarily for a number of reasons. First of all, if you're a multinational working in a number of countries, you will be working in a country where this legislation applies. But even if you are working in countries where it does not yet apply, it will. So, you know, you need to make sure that you're, and secondly, it's good business practice. And so companies have to, I think to me, voluntary compliance is very important. The law is essential because that provides the direction, it provides an even playing field. But to be able to comply voluntarily means that you're ahead of the game and that you ensure that you will not be in a situation where one day you'll be in front of the courts and potentially creating major reputation risk to yourself, but also, as some companies have, lose your company altogether. I think the other aspect is to really look at the subsidiaries that you have and make sure that they also follow as well, and try to help your supply line, which are the small and medium-sized enterprises, which need that kind of support. So, you know, it really means not just having the right code of conduct, of course. It means also having the anti-corruption programs inside of the company, the training of the staff, helping them to understand what they will face, potentially when they face extortion in a country where they work, and how to deal with it. And if you have a zero tolerance and have, you know, the right approach, wanting to do the right thing, then you give a very strong signal to your employees as well, because you don't create a situation of impunity inside your own company. Because if your staff see that the company is bribing, what is it to prevent them from not doing the right thing for the company inside the company as well?
And what is the role of the UN Global Compact on anti-corruption?
You know, as a member of the board of the UN Global Compact, I feel this is one of the very powerful instruments that we have. And what we need is to continue to ensure that we have an increasing number of companies that join the UN Global Compact. At the same time, companies have to be able to report and follow the agreement that they have made in signing up to the UN Global Compact. Now, it seems that until now, companies seem to have been able to report relatively more easily on the first 9 principles. And they seem to have greater difficulty in reporting on the 10th principle. And this is something that we together, the Global Compact, Transparency International, may be working together with our local networks to try to help them better report and report on all principles, especially this one, because this is a very important one for the future of the companies. And we look forward to the companies being able to comply and to comply quickly with all the principles in reporting.
Siemens provides a remarkable example of a company that has grappled with corruption issues, and through that process has become a leader in its anti-corruption activities. The Siemens case involved the highest ever financial penalty for a corporation in a bribery case. In December 2008, Siemens paid $1.3 billion to settle bribery investigations in the United States and Germany. Siemens also agreed to the appointment of an independent monitor for up to 4 years and to cooperate in the U.S. government's ongoing investigations. Discussing the allegations and the consequences is Peter Salmson from Legal and Compliance for Siemens. Mr. Salmson joined Siemens in 2007 as General Counsel and is a member of the Management Board. Among other responsibilities, he's head of Corporate Legal and Compliance. Prior to joining Siemens, Mr. Salmson worked as General Counsel and Executive Vice President at General Electric Healthcare. Before moving in-house, he was a senior partner of the law firm Morgan, Lewis & Bockius, specializing in international mergers and acquisitions and security law. What were Siemens' operations at the time that these offenses occurred?
Since our inception, we've been an infrastructure company. We help companies, we help countries deal with their biggest problems. Our technology and our services going into making the world a better place. But we've been doing this around the world for a long time in some difficult jurisdictions. Now we've got 420,000 employees, we're in 190 countries, and some of those countries are difficult places to do business, and always have been. It's important to remember that Siemens has been international since its inception. In the 1860s, we were doing business in Germany, of course, but also in the UK and Russia, and we had all kinds of difficulties to surmount from the very beginning. Siemens grew quickly. We have been in countries like China, Mexico, Brazil for over 100 years. Over the years, we maintained our founders' values. We were honorable, ethical, and straight with our customers, but we found our way back now.
What were the events that led to the bribery investigations?
I think you have to look at the bribery investigations internally and externally. Externally, the bribery investigations began in November 2006 when 200 Bavarian policemen came to our doors and took documents and arrested people. But the roots of the problem started much earlier. Shortly after the Second World War, Siemens convinced itself that in order to get into certain difficult markets, it was going to have to pay bribes. That was a mistake, and it didn't really come to our attention that how difficult the world had become until about the mid-'80s, when some managers inside Siemens began to raise concerns.
What do you think Siemens thought it was gaining by bribing public officials?
There was a feeling that if we didn't pay, we'd be excluded from public business, and there was one internal estimate that our revenues might drop by 30% if we stopped paying bribes.
What did Siemens lose by bribing public officials?
What we lost by bribing public officials was our own sense of integrity. I mean, at the end of the day, it cost us a lot of money, it cost us a lot of respect. In some parts of the world, it's cost us some business. But what hurts most is the sense that we've lost our way. Our sense of integrity was abused, and we've lost our pride.
How did Siemens make the illegal payments? How did Siemens hide what it was doing from authorities?
Illegal payments have developed over the years. In the old days, the corrupt official simply stuck out his hand and wanted a bribe. Over the years, as corruption has become less and less tolerated in more and more countries, the ways of asking for bribes and the way of paying for bribes has become more sophisticated. One thing that's interesting about bribery payments is they're never out in the open. They're always back alleys or numbered bank accounts. It's always hidden. It's really not accepted anywhere. And so what we saw develop at Siemens was a very complex set of hidden bank accounts, off-balance sheet payments, unconsolidated subsidiaries, and frankly, false book entries. One of the most notorious practices was people would put Post-it notes where there was supposed to be a signature on the theory that when the auditors came, you could remove the Post-it notes and thereby destroy the evidence of your participation. Not very sophisticated, but certainly an indication that people knew they were doing something wrong.
Did paying bribes make Siemens a soft target for officials who wanted bribes?
I think once you start paying bribes, or once you indicate that you're willing to pay bribes, it's very hard to stop. It's a little bit like dealing with the mafia. In fact, sometimes it is dealing with the mafia. And once they have a hold of you, it's very hard to get out. And we had some really tragic cases of Siemens employees who were trying to wind down the bad practices, who were in fear for their lives. There were threats about people being found swimming in the river and so forth. I mean, there's some pretty nasty episodes of people trying to get away from the officials and the crooks who were soliciting bribes. But the lesson is that once you say yes, it's very hard to say no.
In 1999, bribery of foreign public officials was made illegal in Germany. As a result, some people in the company sought to change the way Siemens did business. Why did Siemens' efforts to clean up the company after 1999 fail?
In 1999, there was a change in the law, and it became illegal for German companies to pay bribes outside of Germany. There was an effort inside Siemens to react to that law. Some people took it seriously. There were memoranda, there were discussions, there were meetings, but it wasn't enough. The people who were charged with making the change weren't given sufficient resources. There was resistance within some of the organization to making the change. There was a fear that we would lose business. And so it simply wasn't taken seriously by enough people, and there weren't sufficient resources applied. But I think there's another important point when you think about that period of time in our history. Just because the law changed to prohibit bribes overseas doesn't mean it was illegal or it was legal to pay bribes overseas. There's this notion in Germany and in Europe generally that the world changed in 1999, but it was always illegal to pay bribes, for example, in Italy, where we were caught paying bribes, where employees of ours were convicted for paying bribes. And the excuse that somehow it wasn't illegal in Germany doesn't really make any sense.
When public officials solicited bribes, how did they approach Siemens? Can you give us some examples of how bribes were requested?
How does bribery start? It starts in many ways. In the old days, a public official simply said, "What are you going to do for me?" Or, "Here's what I need out of the deal." As corruption has become less and less accepted in many countries, they become more circumspect. And you hear from a third party. You get a phone call from a consultant who knows about the deal that you're bidding on and implies that you don't have a chance of winning unless you engage him as a consultant. Or you'll have officials ask for things which aren't obviously bribes but are of value. They've never been to Disney World. And there are all kinds of things which are camouflage, but it's very clear that they want something of value. But I would say the prevailing practice these days is there are third parties who pass themselves off as consultants, representatives, even lawyers sometimes, who are merely conduits for bribes.
The Siemens board was sacked during the investigation. What did the board do wrong?
One of the most significant changes after the commencement of our compliance investigations was a massive management change. And this didn't happen overnight, and it didn't happen immediately with everyone, but the board had taken, the supervisory board had taken the decision that it had to look at everyone on the board and find out who, if anyone, was culpable, who hadn't acted properly in the interest of the shareholders, and to figure out which changes were necessary to take Siemens to a new profile, a new place. And so over a period of months, the supervisory board looked at the management, made some changes, and most significantly brought in some outsiders, most importantly Peter Löscher.
How did Siemens go about removing its board members and senior staff involved in corruption?
The process of changing management at Siemens was one that was taken with great deliberation. But I'd say the significant decision that was made by the supervisory board was to get to the facts immediately and thoroughly. Siemens supervisory board took the unprecedented step of starting an independent investigation. They hired an outside law firm and went wherever the facts would take them. They told the law firm, find out how big this problem is, where it is, and how far it reaches. And that was the significant and most important decision. That's the advice I'd give to any other company. If you get into this kind of trouble, move quickly, bring in independent investigators, and figure out just how big the problem is.
What was Siemens' experience of being investigated by enforcement authorities in Germany and the United States?
The investigation of Siemens by the Munich prosecutors and by the Department of Justice and the Securities and Exchange Commission and various other investigators around the world was unprecedented in its size and in its scope, but it was also unprecedented in its speed and its coordination. So what appeared to be an unmanageable and enormous investigation was ended in record time. You think about the investigation started here in Munich in November 2006. On December 18th, 2008, in the early evening, the Munich prosecutors waited for a federal judge in the United States to approve a settlement with the United States Department of Justice and the United States Securities and Exchange Commission. This all happened on one day, an unparalleled coordination, and in record time. Usually these investigations take 5 to 7 years. And Siemens was rewarded for its cooperation by paying fines that were much lower than they might have been. This is what could have been something that dragged on for many years and could have cost Siemens far more money than it did, was allowed or was permitted or occurred because of the decisions that were made early on to get to the bottom of the problems quickly and thoroughly.
Siemens could have been fined almost double the amount that it was in fact fined. What did Siemens do to earn the praise of the Justice Department for its, quote, exceptional cooperation, unquote, and a reduction in fines?
The critical component of Siemens' efforts during the investigations, which were led both by the German prosecutors and the American prosecutors, was its focus on getting to the bottom of all the facts quickly. And that effort, that enormous expense, and all that work by Siemens employees was rewarded in all jurisdictions. And in fact, the Department of Justice made specific mention in its memoranda to the court supporting the settlement that our efforts had been extraordinary. And by extraordinary, they meant both in depth and in speed and in commitment and in completeness.
What has Siemens done to prevent these things from happening again?
It's terribly important to us that this not happen again. We can't afford another mistake. And the most important thing we've done is make it part of our culture. When Peter Löscher, our CEO, and all of our other CEOs speak to employees, they make it clear that our number one priority is integrity. And the lesson that we've learned over the last 3 years is integrity pays. Clean business is good business. We're at a record level of profitability. Market share is up. We're doing extremely well, and we're clean. So the most important thing we do is communicate to all of our employees that integrity is everything.
How has removing bribery and corruption from its business practices made Siemens a better company?
All of our efforts to remove the processes that allowed corruption, to change the culture, has made us better in one significant way, and that is we're proud. When we're asked, how has all this effort paid off? How has all this money, all this time, all this expense of rooting out corruption paid off? The answer is one word: pride. We're proud again. We have the best products, we have the best services, we have the best technology, and now we can be proud about how we present them and how we deliver them. This is nothing new. Siemens has always had this culture. We found our way back to our essential values, and we're proud again.
Ken Thompson is the Senior Vice President and Global Chief Legal Officer for the global legal business of LexisNexis. He's also a member of the Management Committee and Principal Legal Advisor to the Global CEO, and currently a co-chair of the Corporate Social Responsibility of the International Bar Association. As you're likely to be aware, LexisNexis is a service provider to the legal industry. Now, how does LexisNexis contribute to the prevention of bribery and corruption?
LexisNexis is actually in a very unique position to contribute to the avoidance or the prevention of bribery and corruption. The fact of the matter is that bribery and corruption, or the avoidance of bribery and corruption, underpins the rule of law. And the rule of law is of significance to LexisNexis because at the end of the day, it's the reason we are in business. Advancing the rule of law around the world is our underlying purpose as a company. And therefore, it touches us commercially, it touches us philosophically, and it touches us internally. It's something that is simply part of our DNA. And being part of our DNA, we want to make sure that we do everything that we can to prevent bribery and corruption around the globe. We offer commercial solutions. We offer products and services such as LexisNexis Know Your Customer. We offer LexisNexis Anti-Money Laundering. We offer LexisNexis Commercial Due Diligence products. All of those are tools that can be used by us and by other companies to make sure that we find bribery and corruption, we stop it in its tracks, and allow the business to move forward in a healthy environment with a healthy and stable rule of law existing.
How did LexisNexis come to focus on the rule of law in particular?
Well, as I mentioned before, advancing the rule of law is the underlying purpose, and it's the reason that LexisNexis is in business. Now, I wouldn't begin to suggest to tell you that when LexisNexis was first formed, the business objective was, let's go advance the rule of law around the world. But it became pretty obvious pretty quickly that the products and services that we offered were uniquely situated in order to do that. And we embraced that purpose. We embraced that calling. And largely it is a calling at LexisNexis. It is the reason that we've undertaken to publish laws for the first time in many emerging jurisdictions. We've seen that across Africa, we've seen it in the Middle East, we've seen it in locations in Asia. Because if the law is not available, the rule of law cannot exist. And we take great pride in the fact that we have provided those first sets of laws in those jurisdictions. We've also developed and maintain a rule of law resource website where anybody can go. It's out as part of our public website. Anybody can go to it and they can obtain and have access to rule of law materials. We've also done a series of rule of law podcasts which we make available. And the purpose of those is to make sure that people are educated on developments, educated where there are problem areas, and educated about how they can prevent things like bribery and corruption, which negatively impact the rule of law. It's also why we sponsor such things as the World Justice Project and the Rule of Law Index that is published by the World Justice Project. You know, one of the first steps that is necessary in order to make sure that the rule of law is not negatively impacted is to understand how the countries measure up against each other. And it's important that that is done through an independent commission. And for us, the World Justice Project made great sense. You know, LexisNexis wants to play a leadership role to ensure the places where we are engaged, the places where we are doing business, are places where the rule of law thrives, whether it's established firmly or it's a place where we can help make sure that's established, not only for the good of our own business, but for the good of other businesses, the good of that country's economy, and ultimately the good of the citizens that live there.
As a business leader and a lawyer, how do you see the role of business in general in minimizing corruption?
I think that, frankly, businesses like LexisNexis, other socially responsible businesses, have to be the first line of defense with respect to bribery and corruption. The fact is, we've seen some very stringent laws, such as the UK Anti-Bribery Act, that we've all been trying to figure out what it means and how to deal with it and how to implement it over the course of the last year or so. And there have been some stringent laws with respect to these topics that have been in place even before the UK Anti-Bribery Act. But at the end of the day, the enforcement of those laws, the existence of those laws, are always dealing with things after the fact. companies are in a unique position, businesses in a unique position that we can deal with bribery and corruption when it's happening. And if we've properly trained our people and we've equipped them with the appropriate tools, and we have driven through the entire organization how important this is, we can stop bribery and corruption before it occurs. We can stop it in its tracks, we can report it to the authorities, and we can make sure that it's addressed, not only in this situation, but in other situations as well. You know, it really is inherent that companies deal with this as part of their corporate responsibility. We need to work in tandem with the authorities as we move forward with this. It's not, prevention of bribery and corruption requires both pieces. It requires the people on the ground to be trained into what to look for, to understand what the law is, and then a working relationship with the authorities to make sure that where it is uncovered, it's dealt with effectively. In my opinion, these corporate social responsibility efforts around bribery and corruption are not just a nice to have, they're essential. They are absolutely essential. It's our responsibility to our companies to do all we can to eradicate bribery and corruption. And you couple that with the fact that on a very personal level, it's simply the right thing to do. It puts you in a very good place from a personal standpoint, a professional standpoint, and a socially responsible standpoint.
And what contribution do you think that in-house lawyers in particular can make to help business achieve this minimization of corruption?
When you're looking to minimize corruption, if business is the first line of defense, I think the company lawyer is the first lieutenant. We play a particularly critical role. We have a unique skill set, we have tools available to us, and we have an ability to advocate that allows us to shine a light on the problem. And I think that the combination of shining a light on the problem, educating within our company and outside our company, and working with authorities, it puts us in a unique position to make sure that we address the issues of bribery and corruption.
What do you see as some of the most significant challenges facing lawyers of companies that work in jurisdictions where the risk of corruption is high?
I think actually the biggest issue that you face in jurisdictions where the rule of law is not well established when it comes to issues of corruption and bribery is the lack of a well-funded and independent judiciary. The fact of the matter is you can have great laws on the books, but if there is not an independent judiciary there to fairly and uniformly apply the law, and there's no enforcement of that law, it's not going to do anybody any good. And I think that it is especially critical. And by the way, this is not only an issue in developing countries and developing jurisdictions. We see the issue start to rear its head even in countries like the United States, where judicial funding has taken a hit in recent years. And although we may have judges that generally uniformly apply the law, if there's not enough of them, you know, justice at some point that has to wait years and years and years in order to address an issue is not justice.
What are the key contributions that in-house and external lawyers can make to assist in stamping out bribery and corruption going forward?
We need to remember that law in and of itself, regardless of how stringent, is not enough. The principles of corporate social responsibility have a unique and vital role to play in stamping out bribery and corruption around the globe. And we as in-house counsel are in a unique role. No one knows our companies better than we do. No one within the company, or very few people within the company, have the skill set Very few people within the company have the tools at their discretion in order to respond. And I think we as in-house counsel need to embrace that and embrace the fact that we can make a difference. We do have a chance to shine that light that I was talking about. And I think it's a light that educates, it exposes, and it begins to eradicate bribery and corruption. We need to use our skills. And when it comes to the issues of bribery and corruption, we need to make sure that they're applied to stop it. We've been presented with an imperative. It really isn't a choice. Companies are not going to succeed in the long term, and economies are not going to be robust. And the best is not going to occur, either for the company from a profitability standpoint or for the social impact that company can have on society if bribery and corruption are allowed to continue unfettered. And company lawyers can play a key role in making sure that doesn't happen.
What do you see as the relationship between the prevention of bribery and corruption and upholding the rule of law?
The fact of the matter is that the prevention of bribery and corruption and upholding or advancing the rule of law are not just linked, they're inseparable. Without a healthy rule of law, bribery and corruption are going to exist and they're going to grow. With a healthy rule of law, an established rule of law, one that has an independent judiciary, one that has clear and available laws on the books, one that has corporate citizens that are committed to the policies of corporate social responsibility to prevent bribery and corruption. All of those things together bring us to a point where there really is a symbiotic relationship. If you will, preventing bribery and corruption and advancing the rule of law are very much two sides of the same coin.